everyone, and welcome to the second video in week 4 of Law 3006 Administrative Law. This week we're looking at the narrow ultra vires grounds for review. In the first video we talked about just what that means, and now in the second video we're going to look at some of the actual grounds. First up, it should hopefully be a familiar idea to you by now that any administrative decision being made by a government or a public servant must be authorised by an enactment. The enactment, either an Act of Parliament or some subordinate instrument like a regulation, provides the public servant with the power to make the decision. Without that power, the public servant has no greater right to make a decision than you or I do. So Section 5(1)(d) of the ADJR Act formalises this requirement. It says that a decision can be challenged if the decision was not authorised by the enactment in pursuance of which it was purported to be made. So before they make a decision, a public servant must know which enactment provides the power and what boundaries it places around that power. To make this make sense, I want to turn briefly to an important case called Ruddock and Vidalis. This one's also known as the Tampa case, and we met it briefly in the previous video. This was the case where the asylum seekers were caught on a sinking boat, were rescued by the transport ship Tampa, but then refused entry to Australia and invaded by the army. Once the asylum seekers had been detained, Vidalis, a solicitor, applied for their release under a writ of habeas corpus, so he applied to the court to challenge their detention. Now, I don't want to go into too much detail, but one of the key issues in dispute was what powers Australian immigration officials had. Chief Justice Black in the full court of the Federal Court found in dissent that the only relevant powers of those immigration officials were the powers found in the Migration Act. And so to work out whether the Afghan asylum seekers were validly detained, one had to look to the Migration Act and ask for the source of the power. He found that if the Act did not contain the relevant power, and in this case it did not, then the use of the power was invalid. Now, the whole thing was headed towards the High Court when the Howard government retrospectively passed legislation to declare that everything they'd done was lawful. It was a dirty political trick. But even that dirty trick relied on the idea that decision makers need to have power under a piece of legislation. Now that's an authority, but this might make more sense if we look at a simpler example. In Queensland, a young person who has a learner's permit for driving has to complete a logbook of their driving experience before they can apply for testing to obtain their provisional licence. Once they've done that, they submit it for assessment by Queensland Transport. An officer in Queensland Transport must consider whether the logbook has been satisfactorily completed or not, which means there must be an enactment somewhere granting that power to Queensland Transport. If there was no such enactment, they'd have no powers. And so we can open up Regulation 32 of the Transport Operations Road Use Management Driver Licensing Regulation 2010. And Sub-Regulation 32.4 says, after receiving the application, the Chief Executive must decide to either approve or not approve the logbook. There's the power in the enactment. See how it works? Whenever there is a decision by a government decision maker, they should be able to point to the enactment, the statute, that gives them the power to make that decision. If they can't, then the decision is invalid. The second aspect of narrow ultra vires that I want to mention is what we call procedural ultra vires. This one arises under Section 5(1)(b) of the ADJR Act, which says that a decision is reviewable if procedures that were required by law to be observed in connection with the making of the decision were not observed. Sometimes the power of a public servant to make a decision only arises if certain other procedures are followed. The most obvious of these is the making of an application. Let's stick with our example about approving the learner driver's logbook and go back to Regulation 32. Now, the first bit of Regulation 32 says a young driver may apply to the Chief Executive for approval of the young driver's completed logbook. So that's the first procedural requirement. The Chief Executive can't just wander around the Strand demanding to see the logbooks of young people in order to approve or disapprove them. The procedure requires an application, and until that application occurs, the Chief Executive has no powers at all. Sub-Regulation 3 then says the Chief Executive may approve the logbook only if the Chief Executive is satisfied the requirements under Section 29 1A to C have been satisfied by the young driver. Now, we don't need to care what those requirements are. You can see, though, that unless the Chief Executive considers those things, the Chief Executive's powers never spring into existence. So now we have two elements. There must be an application, and then the Chief Executive must consider those specific elements. If those things have happened, then we move on to Sub-Regulation 4, which says the Chief Executive must decide to approve or disapprove the logbook. So you can see the Chief Executive has no power at all until the procedure is followed. The key authority for this rule is a case called Tiong and the Minister for Community Services. Tiong was a doctor and he was suspected of rorting the Medicare system by doing something called over-servicing. This is where the doctor makes more appointments than necessary or longer appointments than necessary in order to maximise the Medicare payment. Now, to make a finding of overcharging, the review board had to first specifically consider a number of matters. Turns out they didn't consider those matters. And so as a result, they never actually had the power to decide if Dr. Tiong was overcharging or not. See how it works? Now, one caveat here. In a case called Clayton and Heffron, the court made it clear that if there was a minor or inconsequential non-compliance, that wouldn't affect the validity of the decision. How do you tell the difference? Well, that's a matter of statutory interpretation. The court will have to decide in each individual case whether a requirement is sufficiently substantial that a failure to comply should invalidate the decision. So here we are at the end of our second video on narrow Ultra Vires. What have we learned? First, we've learned that government decision makers only have the power to make an administrative decision if they can point to an enactment which authorises the making of that decision. Second, we've learned that sometimes the legislation imposes specific requirements which must be met, or else the decision-making power never springs into existence at all. In the final video on this topic, we're going to look at the third aspect of narrow Ultra Vires by considering whether the particular decision maker is authorised to make the decision. See you in the next video.